For the first time in 23 years of decisions under the UDRP, the Uniform Domain Name Dispute Resolution Policy, a panel has redacted or removed the actual domain name from a published decision. This means that when you read the decision, it's impossible to know what domain name was in dispute, even though the decision ordered the domain name transferred to the trademark owner who filed the complaint. And by the way, the identity of the trademark owner or complainant was also redacted from the decision. So what's going on here? Normally in these UDRP case study videos, this is where I would tell you who filed the complaint and what the domain name was. But in this highly unusual case, I can't tell you the name of the complainant or the domain name because the decision has omitted both of those essential pieces of information. All I can tell you is what I know from reading the decision, which was published by the Forum in October 2022 by someone identified only as a published author, artist, and psychologist in Australia against a domain name registrant in New York. And according to the UDRP decision, the domain name was used in connection with what the complainant called an illicit/obscene website, and that it was highly offensive, derogatory, defamatory, and harassing to complainant. The UDRP panelists wrote that the complainant asked for her name, as well as the identity of the domain name itself, to be redacted. Specifically, she said, "My privacy is of grave concern, and I do not want my name to hold any association with the explicit obscene content on the website in question, nor any association with the respondent. I am terrified of the situation escalating. I have evidence and heard from individuals who have received threats in these situations. For this reason, I have a specific request for the forum to aid my privacy, safety, and identity." Now, it's unclear from the decision exactly what was going on here. For example, I have to wonder if the website contained obscene content about the complainant herself, whether the respondent was a former patient of hers, if the site made it appear that the complainant promoted pornography, whether the site expressed specific threats to the complainant or something else entirely. Now, I've filed countless complaints through the years on behalf of my clients involving domain names that were associated with pornography. So this general fact pattern is nothing new, but most of my clients are companies, not individuals, so perhaps the risk of association with obscene content here, especially given the complainant's status as an author and psychologist, is more damaging or offensive. Now, despite the odd redactions in this case, redacting some information from UDRP decisions is not without precedent. In fact, literally hundreds of UDRP decisions through the years have redacted the name of the respondent or domain name registrant, usually because there is a credible allegation of identity theft. In other words, in those cases, there's reason to believe that the name of the respondent is not accurate, which occurs when a cyber squatter impersonates someone else, such as an innocent or unrelated third party, or an employee of the trademark owner who actually filed the complaint. And I am even aware of at least one previous UDRP decision involving the domain name xoariel.com, in which the name of the complainant was redacted to protect personal information. In that case, which was just published last month by WIPO, the decision says that the complainant, an individual, was a well-known content creator and social media influencer known to internet users only by a pseudonym. So in that case, the panel apparently decided to redact the name of the complainant because of concerns about invasions of privacy and violence from aggressive fans once someone's real-life identity is discovered. And as the decision in the case I'm talking about here correctly pointed out, a panel does have authority to redact whatever information it deems appropriate. Specifically, paragraph 4J of the UDRP says, "All decisions under this policy will be published in full over the internet except when an administrative panel determines in an exceptional case to redact portions of its decision." So this case was obviously deemed to be so exceptional that redacting both the name of the complainant as well as, for the first time ever, the name of the domain name itself was warranted. Now, I never would have imagined that an actual domain name in dispute would have been redacted from a UDRP decision, but as I often tell my clients, after handling cyber squatting cases for more than 25 years, nothing surprises me anymore. On the one hand, this unprecedented reaction is a shame, because the UDRP is a very transparent process, with most panelists going to great lengths to ensure that decisions are well-reasoned and clear, which reinforces faith in the UDRP system itself. On the other hand, The facts in this case are clearly incredibly unusual, so I don't expect this to start a trend or really have any impact on the UDRP. In fact, in most cases, my trademark owner clients want the disputed domain names to be published, because doing so may deter other potential cyber squatters from targeting the same trademark, and also inform the public that a trademark owner is taking action to enforce its rights, which ultimately protects its own customers, including those who might otherwise be unwittingly exposed to pornographic or other damaging content online, such as counterfeit products, malware, or phishing activities. If you want to learn more about the UDRP, please check out my masterclass on domain name disputes, as well as other resources on my GigaLaw website. And be sure to subscribe to the GigaLaw YouTube channel to be notified of future videos discussing other internet legal issues. Thanks for watching, and see you next time online.